Okay, welcome everybody. Just gone 12:30. Thank you ever so much for joining us. My name is Lucy Wiltshire. I'm on the Constructing Excellence Oxford Club panel. And welcome today to our webinar. So we're looking at planning for build, unlocking opportunities for development in the Thames Valley. And I'm delighted to welcome both Daniel Lampard and Sarah Moorhouse from Lichfields, who are going to talk to you about this very interesting subject. Thank you. Over to Sarah and Daniel. Thank you.
Thank you, Lucy, and good afternoon, everyone. And thanks to Constructing Excellence for the opportunity to provide a brief update on town planning matters. By way of a brief introduction, I'm Daniel Lampard, and I lead the Thames Valley office of Lichfields, and I'm joined by my colleague, Sarah Moorhouse. Lichfields are town planning and development consultants. We act for both public and private sector clients across a range of development sectors, including housing and commercial development, and we provide a range of services. We operate from 9 offices nationwide, including the Thames Valley office, based in Reading. We first discussed presenting a planning law update with Constructing Excellence a few weeks ago. Since then, the government's been very busy in preparing fresh legislation and other policy announcements. One commentator has described these as the most fundamental change in town centre planning in over 30 years. Whilst not to be outdone, the Sunday Telegraph has described them as the biggest overhaul of the planning system since the Second World War. So there's a lot to get through in the next 45 minutes. Specifically, Sarah and I will be addressing how the planning system is adjusting to COVID-19, amendments to the Youth Classes Order, new permitted development rights, and other potential forthcoming measures. It's no exaggeration to say that these measures could fill several presentations, so forgive us if we move at speed. We'll be happy to follow up directly with any queries that arise, and there will be time for questions at the end. Before we look at some of the government's interventions, it's worth briefly looking at the rationale. In essence, the government is seeking to maintain an electoral coalition ranging from the leafy shires to the former red wall seats. It's committed to both a levelling up agenda and one that supports increased home ownership, whilst also facing an economic crisis following the COVID-19 devastation. And that's where we'll start, with Sarah briefly looking at how the planning system is responding to COVID-19.
Thanks, Dan. So Steve Quartermain stated back in March, before he stepped down as Chief Planner, be practical, be pragmatic, and let's plan for recovery. And in essence, that is what the government has sought to do by introducing a range of temporary and permanent measures to react to the current situation and keep the planning system moving, as well as to plan for future recovery. This slide just provides a brief overview of some of the measures in response to COVID, which have included procedural changes such as enabling virtual planning committees, meetings and inquiries, for which South Oxfordshire Local Plan Inquiry has been the first large-scale virtual planning inquiry. There have also been temporary amendments to publicity requirements for applications, and there has been a temporary relaxation in terms of SIL for SMEs, and that gives additional discretionary powers to the collecting authority to defer payment for up to a maximum of 6 months, and that's in force until the 31st of July next year. So the Business and Planning Act received royal assent on the 22nd of July this year and makes provisions relating to the promotion of economic and recovery and growth. Most of the measures are temporary and to help businesses, and particularly in the hospitality and construction sectors. One of the provisions of the Act is to support cafes, pubs and restaurants by introducing a temporary fast-track process to obtain permission from the local council for a pavement licence. Licences, when granted, also provide deemed planning permission for other works. And the licence should be determined in 14 days and is deemed to be granted if not determined in this time. And once granted, it remains in place for between 3 and 12 months. Another temporary measure is the provision of fast-tracked and deemed consent for developers to apply to local planning authorities to vary conditions that limit current construction site working hours. If approved, it will amend the hours until the 1st of April next year. And again, local planning authorities have 14 days to consider applications, and it's deemed to be granted if not determined in that time. The Act also introduces, from the 18th of this month, measures to provide an extension to planning permissions, listed building consents, and where the submission of reserved matters is required, which have or are about to lapse. For permissions where development must be begun between the 19th of August and the 31st of December this year, there is an automatic extension to the 1st of May next year. For permissions where development should have begun from the 23rd of March to the 18th of August, it will be necessary to seek an additional environmental approval. The need to obtain additional environmental approval may be a frustration for some developers, but these measures weren't widely expected and are likely to be a small price to pay for a planning permission that may or may not have been implemented in time. One permanent measure introduced through the Act is to enable the Planning Inspectorate to apply more than one type of procedure to a planning appeal, depending on the particular issues. So it could be a mix of a hearing, written representations, or an inquiry. The measures were drafted as a response to the pandemic, but the government has concluded that the change will provide ongoing efficiencies and is now a permanent change. Just quickly going on to other measures that have been brought in to respond to COVID-19. This includes the requirement for local planning authorities to take into consideration the impact of COVID-19 business disruption in determining planning applications for the change of use of theatres, concert halls and live music venues. It's making it easier for councils to protect these uses. The General Permitted Development Order is also to be amended to remove the permitted development rights for the demolition of these uses along with pubs. Further to this, councils have been reminded that enforcement is discretionary. In particular, and while less relevant now, the government has emphasised that planning control should not be a barrier to food delivery over the period of disruption caused by the coronavirus. And councils should not take enforcement action that would unnecessarily restrict the ability for caravan and holiday parks to extend their open season. I'll now hand over to Dan to talk about the permanent changes to the use class order.
Sorry about that. Don't have to keep me quiet, but the trouble with the unmute button there. Thanks very much, Sarah. The government's first forays into the youth classes order responded specifically to COVID-19, and they sought to facilitate an income stream for pubs and restaurants which couldn't operate in a conventional manner during lockdown to enable them to operate as takeaways. This was a very necessary shot in the arm for many facilities. They also followed this up with to facilitate other outdoor facilities such as market in an attempt to keep the economy going in these constrained circumstances. More fundamentally, they've now introduced fundamental changes which have amalgamated a range of uses into a single use class. Specifically, this includes shops, financial and professional services, cafes and restaurants, offices, research and development facilities, light industrial uses as gyms. These are now all in the same use class, Class E. Conversely, small local shops, pubs, takeaways and other leisure facilities such as cinemas and bowling alleys, along with schools and libraries, are in their own use classes, perhaps to afford them some form of protection. There are, however, some constraints to this new flexibility. Firstly, the planning permission must have been implemented before a change of use can be put into operation. But change of uses which are otherwise permitted can be prevented by a planning condition restricting the range of use. For example, if there's a condition stating that a unit can only operate as a non-food shop, it won't be able to transfer to other uses such as a gym. Some of these flexibilities are likely to conflict with the government's town centre first agenda, potentially allowing very significant unrestricted developments in locations which, historically at least, governments would have sought to prevent. And local authorities, although it will be entirely possible to apply for a Class E use when these new provisions come in, it's entirely possible that local authorities may regard that as too wide and therefore seek to restrict planning permissions for more conventional uses which accord with the current youth classes order. Finally, one important note is that many of these new many of the new use classes don't accord with existing SIL schedules, which relate to conventional A1, A2, A3 uses and such like, which will all be subsumed. And indeed, large parts of development planning policy, for example, protection for town centre uses to try and retain shops, will no longer coexist with the use classes order as permitted. I'll hand you back to Sarah now. Thank you.
Thanks, Dan. In recent weeks, there's been a swathe of new regulations and amendments relating to permitted development rights. This follows the recent publication of the government-commissioned review of residential properties built under the existing permitted development rights. The review highlighted that compared to schemes arising from planning permission for conversion, permitted development conversions seem to create worse quality environments in relation to a number of factors widely linked to health, well-being and quality of life of new occupiers. Issues included a lower proportion of permitted development units meeting nationally described minimum standards, space standards, a higher proportion of single aspect flats, and a lack of private amenity space compared to the planning permission conversions. There is still no obligation in the new regulations for permitted development units to meet minimum space standards. The government has, however, taken some steps to respond to this report through the introduction of additional requirements relating to natural light for existing permitted development rights, enabling the change of use of dwellings. This came into force on the 1st of August and requires the provision of adequate natural light in all habitable rooms of a dwelling house. And this should not be confused with the right to light. The critical factor, we think, will be the interpretation of adequate. Clearly, the determination of adequacy required by the General Permitted Development Order will depend on site-specific matters and the approach taken by local planning authorities. We're sure practitioners will be closely following the first applications to see what is accepted and the extent of variance from authority to authority. Moving on, permitted development rights for knockdown and rebuild have been introduced to allow vacant and redundant freestanding commercial and light industrial premises and residential blocks of flats to be demolished and replaced by new residential units. The rights come into force on the 31st of August, and the old or existing building has to have been in existence on the 12th of March 2020. It's subject to many conditions, restrictions and limitations. As this first flowchart shows, the existing building has to meet a number of requirements. As I just touched on, it has to be a single purpose built detached block of flats or other single detached buildings established for class B1A, B1B or B1C use. It has to have been vacant for at least 6 months before prior approval is sought. It can't be a listed building or scheduled monument or land within their curtilage. And it can't be a building within a conservation area, area of outstanding natural beauty, and a number of other designations. It has to have been constructed before the 31st of December 1989 and have a footprint of 1,000 square metres or less. And the highest point has to be less than 18 metres above ground level at any point. That excludes plant. It also can't be a building that's been rendered unsafe or uninhabitable. Moving on, the new building is also subject to a number of restrictions, particularly relating to its footprint and height. So the new building can be no more than 2 stories, so that's 7 metres above the height of the old building, but that does exclude plant. There are also other height restrictions. The footprint must be within the footprint of the old building. No part of the exterior wall closest to the highway can become closer to the highway. And also you must apply for prior approval to the local planning authority. There are 13 prior approval matters that are applicable to the prior approvals process. And this means that the requirements of an application submission are onerous and will be assessed by local planning authorities on subjective grounds such as design and external appearance. As a result, councils will have more discretion in determining prior approval applications, although applicants do have the right to appeal. There are new permitted development rights are also being introduced or have been introduced to extend buildings upwards to create new homes and living space. Although, as with all the other permitted development rights, it is important to read the small print. These building upwards PD rights include allowing purpose-built freestanding blocks of flats of 3 stories or more to extend upwards, up to a height of 30 metres, and that came into force on the 1st of August. As with knockdown and rebuild, there are limitations, conditions and restrictions, with it only applying to blocks built after the 1st of July 1948 and before the 5th of March 2018, and a requirement to assess 8 prior approval matters, which includes natural light to existing occupiers. The second phase of new permitted development rights to build upwards allows up to 2 additional stories on freestanding blocks on buildings in a terrace or 2 or more in certain commercial uses, and it also allows up to 2 additional stories on existing houses, detached or terrace, to create self-contained new homes or additional living space, and that's up to a height of 18 metres. If it's a single story home or building, you'll only be able to add 1 story, and these regulations come into force on the 31st of August 2020. All these new measures are a significant step change from the scale of development permitted by the permitted development rights relating to residential development currently, which have often been used as a fallback position. It remains to be seen how the new permitted development rights are going to be implemented, but some commentators have suggested that some developers may just choose to regard these rights as, again, a fallback position as part of the planning application process. However, the costs involved with knockdown and rebuild may not make that as attractive. I'll now hand over to Dan to talk about planning for the future.
Thanks very much, Sarah. Yes, the government have announced an imminent, albeit as we enter August, now delayed policy paper, which they've indicated will support the economy and deliver land for more housing. In looking into the tea leaves, we anticipate there'll be a continued focus on home ownership, including first homes, which is a new form of discounted market sales tenure. Other measures drawn from recent speeches and musings suggest there'll be greater reliance on technology, perhaps building on some of the benefits that Sarah touched on, getting away from sticking a signpost on a lamppost, constituting consultation. There may well be alterations to fees, possibly related to performance, and possibly penalising local authorities when it's necessary to go down the appeal route. And not for the first time, there's likely to be an encouragement for greater use of compulsory purchase powers to unlock land ownership, as well as delivering infrastructure. Separately to this, the government have responded favourably to the Building Better Commission, which was published at the start of this year. And there's a suggestion that the government stated they'll seek to implement as many of the proposals as possible. Some of them will require legislation, some of them are just best practice, and it wouldn't be surprising to see some of those elements taken forward within the forthcoming policy paper. I suppose perhaps the biggest surprise, the most radical element, was reported in the papers on Sunday, where the Secretary of State indicated that all land, were his words, all land in the country will be designated in one of 3 categories: for growth, for renewal and for protection. Based purely on a newspaper article by the Secretary of State, the indications are that land which is for growth means that new homes, hospitals, shops and offices within these areas will be allowed automatically, or alternatively, one of the follow-up articles suggested that will be a presumption in favour of them. So it depends which newspaper you read, albeit all should become clear soon. Land for renewal will enable permission in principle, the theory being a speeded up version of the planning application route that we have now, with the intention of balancing speed whilst ensuring that checks are carried out. And protected land will be just that. So the government's stated intention, details to follow, is to look to cut red tape, but not standards. Now, a number of queries arise from this approach, and many of which may well be addressed when the policy paper is published, which is literally any day now. But three immediate queries that arise are if the government, if the summary is correct and the government are suggesting that all land within the country should fall into one of the three categories, that is no small task. That suggests a revisiting of the local plan process, which to some extent is always being revisited, but numerous local plans are going through the system now. Numerous plans have been adopted recently, and that is an entirely new form of assessment if the indications about that are correct. Secondly, there's a lot of reliance on design codes and the suggestion that schemes will need to conform with design codes. Now, that's not necessarily straightforward, because design codes and application of them is often open to interpretation, and that in itself, whilst it may speed matters up to have far clearer guidance on design, but there may well still be disputes about that. There may well still be appeal processes relating to that. So uncertainty at this stage as to how that will work. In terms of protection, the examples used were Greenbelt and AONB, but how far down does protected land go? You can imagine the controversy of open countryside, which is often largely protected by planning policy, not being put into a protection area. But equally, if it is, what does that mean for the future of flat planning if those uses are fettered? And also, within almost any form of protected land, be it Greenbelt, AONB, there is always the possibility that development can come forward because it's recognised that there are exceptional circumstances, and that's one the planning systems always does, is to balance the protection against the need for development and harm arising against the benefits from it. So again, codifying matters doesn't necessarily remove the judgments that we have to make, and from perhaps the government's perspective, that slow these down. So it really is a case of watch this space. It may well be, there may well be clarity, some clarity on it by the end of the week. Other matters may continue to run. But it's certainly a very challenging agenda that the government set out. And at the end of it, large parts of the planning system may not be recognisable to how they are today. So thank you for listening, and Sarah and I'll be happy to answer any questions that you may have.